This courtroom showdown has everything: 14 felony charges, a nursing school dream hanging by a thread, and a plea deal the judge just can't stomach. Crystal Dogan walks into court hoping to walk away with probation. But what unfolds instead is a fiery legal back and forth that spirals into pure chaos. Will her past catch up to her? Is restitution enough to save her from jail time? And just wait until you hear how she exits the courtroom. Buckle up, because this is one legal roller coaster you won't forget.
Are you Crystal Dogan? And Ms. Bogan was previously in court, entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine, as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report?
Yes, I have.
And any additions or corrections or?
There's a lot of history we understand, Your Honor, but discussed it with counsel also with restitution.
Speak up, I'm
I
sorry.
just want to make sure the court knows restitution, most of the main issue we're looking at, get some of that money back.
I've got 1, 2, 3 and a quarter pages of criminal history. Well, there's a lot of stuff that wasn't dismissed. There were 14 felonies that weren't dismissed. At least 4 or 5 misdemeanors that weren't dismissed.
And there it is, the avalanche of past offenses. The judge isn't just glancing over a record. He's flipping through pages of felonies and misdemeanors, like a rap sheet novella. 14 felonies not dismissed. That's staggering. And right here's the crux. How does someone with such a track record expect a lenient deal again? Viewers, what do you think? Is a fresh start possible with this kind of history, or should consequences be unavoidable at this point? Drop your take in the comments, can people really change? Or is this just another courtroom déjà vu?
Understand the restitution, and y'all know my position on that already this morning, but she's on probation right now in Sutton County, correct?
Yes.
Right. So do they know about this case? And what has happened over there, if anything?
I'm continuing on my degree. Because I'm actually supposed to start nursing.
I can't understand you.
I'm supposed to start nursing school.
When?
I was actually supposed to start in September, but I had to wait to see.
Are you really going to be able to go to nursing
Yes,
school
ma'am.
with this type of criminal history?
Yes, ma'am. Either that I haven't been convicted of it. I'm a CNA now.
Where do you live now?
In Houston.
Another issue that I see on here also is the restitution, because it shows $9,400, but then it also, that was from inside the bank, and then it shows $500 from an ATM and $100 from a cash app, totaling $10,000, not $9,400. Is that correct?
And that would have been added on, I guess, I think, fee.
Well, it says 500 was withdrawn from an ATM outside the bank. Is that right? You know better than anybody.
I only went into it. I didn't have no access to the card.
Okay. So possibly the other person that was involved did that?
The only thing we knew about
That was,
was 100 that was in the bank.
I wasn't aware, Your Honor, when we did it and got when I got the PSIs, when I was notified, I was in the cash wrap. But if it was a withdrawal, then that would be her responsibility, joint and separately.
Right. It says, so
Just a request.
the contact from Do Good said that the defendant withdrew the entire loan amount of $10,000, $94 from inside the bank, $500 from an ATM, and $100 from a cash app transaction. It doesn't matter if you did it or if the other person that you were with.
Now this gets tricky. Crystal claims she only accessed funds inside the bank, but we're looking at $10,094, withdrawn across multiple platforms, ATM, Cash App, and the bank itself. She points fingers at a mysterious second person, but offers zero names, zero details. Legally, joint responsibility sticks like glue in cases like this, so unless she can prove otherwise, the court will treat them as co-conspirators. Here's the question for you. Should courts be lenient if someone claims they were manipulated by an unseen partner? Or does silence equal complicity? Let us know what you think.
Did it. Y'all were working together. So you're both, and what's the other status of
I
the,
don't have the status of another person, Your Honor. This is one that was in charge. But not there's a person on there. But
okay.
she was responsible.
Yeah. So I mean, if there was another person, and you didn't give that information, then that's, okay. Apparently the cops didn't either, so.
She went in the bank. She was on the house. Well, I'm not getting the back. Not to my knowledge.
And hold on. So the probations in Sutton County, have they been transferred to Harris County? So you're going in person in Harris County? Okay. And so it's the state's position to go forward with the agreement?
I understand the court's concern. The state has the same. Like I said, our initial deal was to get some of the money back on our victim. However, we understand.
All right, so here's what I'm going to do, Ms. Bogan. I'm going to find that you entered your plea of guilty freely and voluntarily. Can y'all hold it down over there, please? I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. I just don't know. I just can't believe I'm even considering doing this, honestly.
Excuse me.
I'm not. I can't. There's no way. It has to be straight probation, and I realize that that's going to potentially have some issues, but I can't with 14 prior felony offenses, same type of thing. So
I know.
you
No,
do.
no, I know. No, I don't.
Okay. How many do you think you have?
I have 3 here and one back home.
Okay, you have lots of them that were at the same time for different offenses.
This is the turning point. The judge weighs the plea and flat out, rejects it. Why? Because probation after 14 prior felonies, many for the same offenses, simply too much to overlook. This isn't a first-time slip-up. It's a pattern. And the judge calls it exactly that. Notice how he dismantles the idea of consolidated charges, reminding us that legal paperwork may bundle cases. But accountability remains one by one. If you were on the bench, would you have allowed the plea? Or would you do exactly what the judge did here? We want your verdict.
Yeah, you did probations for them. Forgery of a financial instrument. Don't talk over me. March 3rd, 2008, Harris County, 180 days in jail. So that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation. So that's 2 in Ohio. March of 2014, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all of that. It was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm going to run out of fingers. March, another one, a theft, aggravated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 1, 2, 3, 4, 5 continuous smuggling of persons for pecuniary benefit. And that's the 10-year probation that you're on in 5 different cases. That's not correct.
No.
So how many cases are you on probation for in Sutton County?
It all ran together. So.
I understand it all.
one.
It doesn't run, but that's not how it works.
Yes, ma'am. Yes, ma'am.
When it runs together, it just means you're serving it at this. I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. We'll see you back in 3 weeks. Y'all can talk about it then. You're at, ma'am,
What?
this is not going to help.
It don't matter. My life's fine.
Well, looks like you did that, not me. I'll see you in 3 weeks.
Bullshit.
Come on, hold on, get her. Don't let her go. Come back. Everybody heard it.
You're bullshit.
Come back.
Sure, lawyer.
I told my lawyer she was bullshit. I didn't say this.
You don't talk like that to anybody in this case because he didn't do this either. You did.
He is, I mean.
He did get you he did a great job. I'm going to find at this time that your bond is not sufficient because of your attitude and because of your
I gotta go to work. So I'm gonna lose my dog and everything too.
Well, maybe you shouldn't cuss at your lawyer. Maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond currently set at? Don't cry now after saying it's bullshit to him and acting like this in here. Stop.
Ma'am.
No, you're going to make it worse. You're just going to make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. All right, I'm going to set your bond.
And just like that, the plea deal is torched. The courtroom spirals into mayhem, and Crystal's bond shoots to $25,000 after a meltdown that even her lawyer couldn't contain. This case is a prime example of how courtroom decorum, past choices, and emotional control collide. The judge didn't just weigh the legal facts, he responded to attitude, accountability, and respect for the process. The takeaway, when your freedom's on the line, every word and reaction matters. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Until next time, stay sharp, stay informed.